Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7001. Fraunhofer-Gesellschaft zur Forderung der Angewand Forschung e.V. versus Sirius XM Radio Inc. Maicha and Nguyen appellants. Mr. Bagdasarian for the appellant, Mr. Murthy for the appellant.
Good morning, counsel. Mr. Bagdasarian, please proceed when you're ready.
Good morning, Your Honor. May it please the court. I'd like to start argument today with the issue of whether the judgment is a final appealable order from the district court here. As our briefing made clear, and as the cases this panel has identified make very clear, there can be no question that this is a final appealable order. In fact, the Service Employees International case from this court is on all fours with our situation here. I'm happy to answer any questions the panel has on that. And if it doesn't have any questions, I'll turn to the question of whether this court should hear the appeal under 1295 or whether it should be transferred to the federal circuit.
I mean, the finality question affects that too, right? Because in order for it to go to the federal circuit, in order for the federal circuit to hear the case, it would still have to be final.
Yes, Your Honor. That is one of the prongs of the analysis. And I think because it is a final appealable order, that prong of the analysis, purposes of transfer, is readily satisfied. The second question under transfer is obviously in the interest of justice. And that leads us to the very question about whether 1295 affords the federal circuit the exclusive jurisdiction over the underlying action that we have here, which is basically, from our perspective, an issue over a subpoena. And our argument under 1295, under the current iteration of 1295, is let's look at the text there. And the text of 1295 currently reads that any action in any district court in the United States arising under any act of Congress relating to patents is within the exclusive jurisdiction of the federal circuit. Your Honors, our point is this is a subpoena case. This is a subpoena issue.
So do you think that the decisions that go against you, like Dorff in the Second Circuit and the case from the Fourth Circuit, and I can't remember the name.
McCook, I believe.
McCook, thank you.
Yes.
You think those are different because the text has changed?
Yeah, Your Honor, yes, we do. We understand the argument on both sides. All those cases that Fraunhofer's presented to this court went off on the in part of, based in part of. The previous iteration of the statute read in whole or in part. The current iteration of the statute says arising under. And I believe what Fraunhofer has presented to this court, in all those cases that Your Honor referenced, made the decision, including the federal circuit's own decisions, the Dorff and McCook case, all reached the conclusion that the federal circuit has exclusive jurisdiction using the base in part language. And here we have arising under. And we believe the arising under requires more of a direct link, not a one-step or a two-step remove from the underlying act.
But what other statute gave DDC jurisdiction other than as a piggyback on the patent action that's in the District of Delaware?
Your Honor, it did piggyback off the jurisdictional of the underlying case in Delaware. There's no dispute there. Our only point under 1295, 1295's language does not require a tracing back to the original jurisdiction of the patent action between Fraunhofer and Sirius XM. That's the arising under language. The base in whole or in part leads you more to that because base in part.
But I guess my question is, something had to give the district court for the District of Columbia jurisdiction.
Of course.
And what is it if it wasn't the patent jurisdiction that the District of Delaware had, and then this is an adjunct to that? What's the other jurisdictional basis for the district court for the District of Columbia, apart from it can't be the federal rules, so it has to be some statute. And what statute is it?
It is 1338 that gave the original Delaware court the jurisdiction to hear the underlying patent case. And the District of Columbia had its jurisdiction based on that statute. There's no disagreement there. Our only point under 1295 goes to whether or not the Federal Circuit has exclusive jurisdiction over certain appellate matters. And we looked at the text of that statute. And when we go back to the text of that statute, the current iteration of it really discusses arising under any act of Congress relating to patents. And that's the distinction we're making between the two situations. It is very much an issue of first impression, not only in this court, as far as we can tell based on the case that Fraunhofer presented to it. This may be an issue of first impression because that new language came into being in 2011, and cases like this oftentimes don't get to this level that quickly. But that's our distinction based on the text of 1295.
Okay. So just to follow it through one step further, the DDC action is a civil action, right?
Correct.
Right. And so, does it arise? Did the civil action in DDC, the one that you're trying to appeal here, did it arise under any statute?
Did the District of Columbia action arise under any statute? The jurisdiction of the District of Columbia action was based in part on the underlying patent action in Delaware. That I agree with.
So did it arise under that?
Well, I make a distinction between arising under.
Right. So then, but if it didn't arise under that patent statute, did it arise under something else? Or are you just saying it didn't arise under anything?
Well, it arose under the patent statute. The issue,
but if that's true, then isn't the text satisfied?
Well, that's my point, is that it depends what arising under means. And I'm making the distinction between arising under in whole or in part, which is what the previous language was. And my only point is arising under needs more of a direct link rather than, I don't think there's a jurisdictional question in our view is relevant to the question of what Federal Circuit's exclusive jurisdiction is or not. I think the District of Columbia could have jurisdiction based on the jurisdiction conferred and piggyback on the jurisdiction in the original Delaware action. But when we look at the 1295 statute and we go back to the text of that I think that we look at that text and determine based on that text, does it arise under? And the question is, does it have to be directly, or do you need to trace it back to the original jurisdiction in the Delaware action? And it's our view, there's a reasonable view that does not need to happen.
So let me just ask one more question, because I think I keep asking the same question, but I just want to make sure I understand your argument, at least for your own benefit.
Sure.
For 1295 purposes, your view has to be, and I think it is, that the DDC action did not arise under the patent laws. Because if it did, it has to go to the Federal Circuit. So your view has to be, for 1295 purposes, it did not arise under the patent laws.
It did not arise under the patent statute because it was indirect.
So then my question is, if it didn't arise under the patent statute, did it arise under something else? What did it arise under? Or does it just not have to arise under anything?
Well, it arose indirectly, not directly. And 1295, because there's another way to get to appellate jurisdiction under 1291 as opposed to 1295. Our distinction between the two is which court is going to hear that appeal. And if this court accepts our view that indirect is insufficient, well, then we stay in this court for all the reasons we've talked about. If arising under can be, and you do need to trace it back to the original jurisdiction of the Delaware court, well, then it is reasonable to transfer it to the Federal Circuit for the reasons we've articulated.
So you're basically, what you would do at the end of the day, I'm not saying this is wrong, I'm not saying it's right either, but what you would do at the end of the day is under 1295A1's current iteration, you would basically insert the word directly in front of arising under, and you would say, well, it did arise under the patent laws, that's why the DDC had jurisdiction, but it didn't directly arise under the patent laws, and that's what you would need to get to the Federal Circuit rather than our court.
That in our view is a reasonable reading of 1295. We understand the other view of it, certainly, and if this court accepts the other view, we would respectfully request that the case be transferred to the Federal Circuit if this court doesn't retain jurisdiction. I'll reserve the balance of my time.
Okay, thank you, counsel. Mr. McPhee?
Good morning, and may it please the court. Fraunhofer submits that this appeal should be dismissed for lack of jurisdiction, or in the alternative, transferred in whole or part, whatever remains, to the Federal Circuit. And I say that with some ambivalence because we would rather just have the case resolved on the merits here, be more efficient, but we're mindful of this court's careful watch on its own jurisdiction. But to that end, I'd like to start with a question that you posed regarding the two cases, Budenick and service employees. We do think that those cases are not quite on point for at least the following reason. In both of those cases, there was not only a finding of contempt, but also a sanction that was issued. So in Budenick, there was a finding that attorney's fees would be assessed. The only remaining issue was the amount of those fees. And then service employee, the same thing. There was an award of attorney's fees and also a conditional fee of, I think, $20,000 if the arbitration didn't occur within a specific time period. By contrast here, the district court made a finding of contempt and did ask for information about what fees Fraunhofer had incurred, but there was never any issuance of an actual sanction. The district court never said, I am going to award the attorney's fees once calculated, never said I'm going to give some fraction of those or a multiple of those, or maybe some other fee or a non-monetary sanction or no sanction at all. And that distinction really does make a difference. If you look at service employees, they cite to Wright and Miller, the treatise 3917, that actually has an articulation of this rule. They say a determination that contempt has occurred is not final if the question of sanctions is postponed. And Wright and Miller in footnote 4, they cite a number of appellate decisions in support of that rule. I can cite a few of those for the benefit of this court. So one is Petróleos Mexicanos versus Crawford, 826 Federal 2nd, 392 at 398. Quote, a contempt decision's finality and appealability is composed of two parts. One, a finding of contempt, and two, an appropriate sanction for that contempt. And you see the same rule in the Ninth Circuit Weyerhaeuser case. There's an SEC versus Naftali case in the Eighth Circuit, and other cases that are cited there in Wright and Miller. So I should say all of these cases now are consistent with what you see in Budenick, which is that you have finding of contempt and a sanction to be applied. And it's further consistent with a case that that appellant cited, actually an older Supreme Court case, Alexander versus U.S., which says that the right of review arises once the court punishes the witness for contempt of the order. And that's on page 4 of the reply. So that language, we think, supports the Wright and Miller rule as well. And we did look to see if there was even a single case where a finding of contempt without a sanction was found to be final and appealable, and we did not find any. So we think that the better view, the best view of the law on this finality issue is that this case is not final. We do not have that sanction that gets you over the line.
So in service employees, you think what distinguishes it is the $20,000 sanction?
$20,000 conditional sanction, as well as there was a finding that attorney's fees would be levied.
So the finding that the fees would be levied, even though the amount of the fees hadn't been determined.
Correct. And we think that's a significant difference. It's an actual sanction, a punishment that is concrete in nature, even though some of the mechanics, the amount has yet to be determined.
I'm sorry.
Oh, please.
Let me make sure I understand your argument. Suppose I'm starting from the point that Federal Circuit has exclusive jurisdiction. And so the inquiry has nothing to do with the finality question that you're now talking about. It has to do with transfer. They've raised the request to have this transfer under the statute. We're supposed to look at that, and if the conditions are met, we're supposed to send it to the Federal Circuit.
Yes, so that takes us to the next issue, which is...
And I'm saying suppose that is the issue in my view. In other words, yes. I as a federal judge am sitting on a circuit that does not have exclusive jurisdiction to hear this. Another circuit has exclusive jurisdiction to hear this. We don't have exclusive. And you're not disputing that the Federal Circuit has exclusive jurisdiction, right?
That is correct.
Okay, so if that's, we're both starting there, it seems to me that's the starting point. This is the Federal Circuit case, not a DC Circuit case. And so now how, in your view, how should we proceed?
Yes, I fully agree with that, Your Honor. The question of transfer has implicit in it a question of would there be jurisdiction in the transferee court, which is why we then ask that initial step, is there a final decision to review at all? So I believe that question comes into the transfer issue, but there is a larger question that has been raised just now and in the papers, which is this case properly within the scope of the Federal Circuit's exclusive jurisdiction to begin with? I think that actually is a very, very straightforward issue. The statute itself, Supreme Court case law, the Federal Circuit precedent, and every other appellate court to consider this issue has ruled without question, without variance, that an ancillary discovery proceeding that is conducted in service of a patent case falls within the exclusive jurisdiction of the Federal Circuit.
So, but to be within the exclusive jurisdiction of the Federal Circuit and something that could be appealed to the Federal Circuit, it has to be a final decision.
Yes, that's right.
And then to judge that, do we judge finality by reference to well, first of all, do we judge it? And if we judge it, do we judge it by reference to DC Circuit finality law or Federal Circuit finality law? Since the question is whether it could have been brought in the Federal Circuit. Transfer purpose.
That's an interesting question, Your Honor. I don't know that there's a distinction between DC Circuit law and Federal Circuit law.
Well, not the way you're looking at it, because you think it's non-final either way. But what I'm saying is, if it's complicated under DC Circuit law because of the service employee's decision that you've tried to distinguish, but it's maybe not as straightforward as might be optimal for you, doesn't matter, because if it's a case that needs to have been, that it could have been brought, needs to be the case that it could have been brought in the Federal Circuit, then the Federal Circuit would apply its own finality rules to decide whether it's final for purposes of bringing it in the Federal Circuit, which seemingly would put this in the can of Federal Circuit finality law rather than DC Circuit.
I think that's right, Your Honor. I think that's the better rule. It falls more cleanly within the scope of what the exercise is here when you look at transfer. I will say I don't think it makes a difference in this particular case either way, but I do think that's right. I did want to address... Okay,
and then can I ask on this question of whether it actually belongs exclusively in the Federal Circuit? So you heard your argument from your from opposing counsel that the language of the statute has changed since the decisions that you very understandably rely on that were completely parallel, except that something happened in the interim and the text changes. So now it speaks in terms of arising under. And what do you make of the argument that, well, arising under basically means directly arising under, which is something more than the one step removed connection to the patent laws that exists when the discovery dispute is in one court and the underlying patent action is in a different court?
Yes, I see no basis for that interpretation whatsoever. I certainly didn't hear any authority or case law in support of that interpretation. I think that whatever change in language in the statute is a distinction without a difference. The authority, the jurisdiction of the DC District Court had to arise from somewhere. And the only source that we've been able to identify for that is, in fact, 1338.
So you think the DDC action arose under the patent statute?
It had to happen.
1338.
Absolutely. And that's consistent with all the prior cases we see. We can't just imagine a jurisdiction. Certainly, we've seen that the federal rules themselves, Rule 45 of the Federal Rules of Procedure, does not grant jurisdiction to district courts, and the case law is clear on that. It had to come from somewhere. The only source that is available here is 1338. It's an open and shut case. I don't see any reason why that statutory language change makes any difference here.
The two ways we might look at, when we think about transferring this to the Federal Circuit, we could look at it and look at the statute and say, we don't think the Federal Circuit would take this because it's not a final order. And they have a lot of case law that says contempt orders pending sanctions are not final. So they wouldn't take it. That's undisputed. The Federal Circuit has that law. So one possibility would be for us to say, I want to make sure I want to understand what your thinking is. to say, therefore, we just dismiss. We don't have any jurisdiction. They wouldn't take it, so it's over. The other thing would be to say, and I think I know what you're going to say, I want to say that the Federal Circuit has never expressed a view as to how they'd handle a situation if it arose as in service employees. And that presents a different inquiry, and they haven't spoken on it, so we should simply transfer it, and they can handle the case however they want to. The only thing we know is we don't have any jurisdiction, so let them do it.
I would say, Your Honor, the first option, I think, is the...
Well, I know what you'd prefer, but what's your reaction to the second? Obviously, you prefer the first. The first is clean and easy, but you can make the argument that in the cases in which the Federal Circuit has pronounced, if sanctions are still pending, it's not final. It's the Federal Circuit has case law like that. There's no question. But you can say service employees raise a different situation. They have never spoken about how you handle the finality question in a service employees type case. I'm not saying that DC law binds them. I'm just saying, as far as I can tell, the Federal Circuit has never addressed that situation.
And I'll be very honest, Your Honor. Candidly, I think either approach could be acceptable. I don't know that the case law clearly mandates one or the other. I don't know that we clearly have a preference either way. We're looking to get this resolved as efficiently as we can.
Thanks.
Thank you.
Thank you, counsel. Mr. Bagassarian, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. Just a couple of points. The sanction here, and we disagree with the sanction, was the contempt. The only thing left for the district court to determine is what she asked for, is the amount of monetary sanctions, attorney's fees, what have you. That makes this on all fours with the service employees case. That's all that's left. The question about whether it was raised regarding whether this court should decide the question of appealability under service employees or go to the Federal Circuit. I think under the analysis, it makes sense for this court to apply the service employees case, since all of the transfer analysis needs to be determined part of that. But from our perspective, all we're looking for is to have appellate review in some court. And if that means going to the Federal Circuit, we'll do it there. If that means having her appeal heard here, that's fine with us. We understand we have to figure out the jurisdiction, which court has proper jurisdiction. If you apply service employees, there's no question we have final appealability, and then the question becomes under 1295, which we've already discussed. If this court decides to choose to say, well, Federal Circuit, looks like you have exclusive jurisdiction over this, well, you decided. I don't know that we're opposed to that in any way, but our only point is to make sure that she has some form of review. Our concern with Fraunhofer raising this issue was try to avoid any appellate review altogether. It sounds like they now abandoned that argument, which is somewhat comforting. But all Ms. Nguyen is looking for is to have an appellate review at some point. And it does make sense for it to happen now, whether it's in this. Well,
even for finality purposes, there's no doubt that there will be appellate review at some point. It's just a question of whether it's premature, right? Because once the attorney's fees are settled, then everybody agrees there's appeal.
No, I agree with you absolutely. I'm just pointing out that they tried to raise in their brief the ability of this court to take a peek at it and just dismiss it outright. I'm arguing to you that is not an appropriate outcome based on the case. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-1162, Ohio Nuclear Free Network and Beyond Nuclear petitioners versus U.S. Nuclear Regulatory Commission and United States of America. Mr. Lodge for the petitioners, Mr. Michael for the respondents, Mr. Fant for the intervener.
Good morning, counsel. Mr. Lodge, please proceed when you're ready.
May it please the court, I'm here representing the Ohio Nuclear Free Network and the Beyond Nuclear organization here in Tacoma Park. The legal issue here today is whether or not the National Environmental Policy Act affords a claim or cause of action or means of objection to a Nuclear Regulatory Commission licensing proceeding that is not bounded by the Atomic Energy Act. It's our contention that NEPA, because of its commenting process, because of the fact that there are clear indicators that public involvement is essential, that NEPA affords an independent means of challenging the license request, the license amendment request in this particular case. We're here to confirm the public's role in some very consequential decisions that are being made, confronted with the specter of climate chaos, as well as the renaissance, apparently, of consideration of nuclear power as a means of generating electricity, as well as a means of creating international commerce. There's a very obscure but very important decision that was made by the NRC to grant a license to Centrus Corporation, a firm that is engaging or about to engage in the centrifuge development of a new type of nuclear reactor fuel. Therein is the difference. It's called high-assay, low-enriched uranium, HALEU for short. I will try not to inundate the court with acronyms, but HALEU is to be enriched to just shy of 20% content of uranium-235. Uranium-235 is, in some contexts, a weapon material, nuclear weapons material. The license actually allows Centrus Corporation to exceed that 20%, roughly 20% threshold, and actually enrich as high as 25%. This material can be very attractive for trafficking, sabotage, theft, ultimately for the making or becoming
before you get too far down the road on the merits question about NEPA, there's a threshold question about whether we have jurisdiction over your petition because under the Hobbs Act, you need to be a party aggrieved. Yes. And there's this question about whether you're a party aggrieved, given that under the regulations to actually have participated in the underlying administrative proceeding, something else had to happen besides the email that you sent. So can you speak to that question?
Well, first of all, Your Honor, we provided 105 organizations, cross-section of United States environmentalism and anti-weapons organizations, signed a 5-page single-spaced comment letter that we provided in March 2021. The Hobbs Act is pretty clear, according to precedent, much of which is from the DC Circuit, that the Hobbs Act doesn't defer to an agency's determination of who is a party, but requires the courts to make that decision. The Rayblatt decision, a 1997 DC Circuit decision, at page 24 of our brief, we discuss that the court discusses that if agencies were left to their own devices, they could simply deny the public or anyone who wants to seek judicial review by simply saying they're not parties, defining them as non-parties because they only submitted comments under NEPA and didn't.
But there are certain procedures. There are certain procedures prescribed by the agency for intervening, right?
There is a procedure for intervening,
and it's permissible for them to adopt those procedures, right? I can't. I mean, I've looked all over, and there's nothing that's impermissible about what they've done. This is not an APA. This is not a free-floating APA action with your cause of action under NEPA. This is I just looked at your complaint again. You are admittedly under the Hobbs Act. So you have to follow the procedures that are associated with a Hobbs Act challenge, which it seems to me includes complying with the agency's procedural obligations, which includes, if you want to intervene, there's certain things you do, and if you don't do them, you're not in.
Well, Your Honor, we believe that NEPA, under the Limerick Ecology decision, which is the First Circuit decision from 1989, actually, NEPA is held to be a separate statute, which is not bounded by the Atomic Energy Act. But in direct response to your question as to the AEA setting forth a procedure, what the Nuclear Regulatory Commission has done is they've created an adversary proceeding as to whether it is even allowable for one to raise a NEPA type of criticism of a plan. And the standards, the NRC has very proudly stated that their standards for granting intervention are strict by design. They certainly work well in keeping out many public interventions. And the fact that there is an AEA procedure does not foreclose legally or in common sense terms a comment, submission, and subsequent litigation, if need be, based upon the National Environmental Policy Act. In fact, the only way that one can participate under NEPA, according to NEPA, is by comment, if you're a member of the public. We believe that the demand involved a request for a publicized environmental assessment. This was not an EA FONSI, environmental assessment with a finding of no significant impact, was the NRC's conclusion after a completely non-public proceeding. It was initiated by a very obscure announcement sometime before the EA FONSI was published. But the point is there was no circulation, consultation with other federal agencies, and there was no posting of the environmental assessment for public comment as a precursor to ultimately making the decision they did. They found no significant impact and issued the license a week and a half later.
Is there a reason that you couldn't have participated via the written request route that's set out in the regulations? I know you have the argument that the agency doesn't get to define it. I get that. And of course, it's true that at the end of the day, the court has to decide whether you're a party aggrieved. But I'm just wanting to know as a practical matter, is there a reason that route was unavailable?
Other than the fact that we believe that it is largely an unattainable aspiration, the AEA process, no, sir. Correct. I mean, yes.
It's unattainable. Why? I'm really not following your argument. There's an intervention requirement, right? And you can petition to intervene.
No, sir. The NEPA process is a separate type of proceeding.
No. I understand NEPA can stand alone sometimes, but the problem is this is a Hobbs Act case, and you admittedly used the Hobbs Act to challenge the relicensing. That's what's really going on here. NEPA is among the objections that you want to bring to challenge the relicensing, but this is a Hobbs Act case, and so when I looked at the case law, there's certain requirements you have to follow, including the requirements that the agency has set forth for participating. And if you don't, then you haven't. And if they refuse to allow you in, it seems to me that's objectionable, and you could bring that question to court. That's not what you've done. In other words, if your argument is that we were not allowed, we were impermissibly denied the right to intervene to challenge this license, that's fine. You can raise that, and then you get an answer. That's not what's going on here. You're saying we don't have to intervene, and because NEPA, in some situations, is a standalone cause of action. 1331 is the way you use the APA. That's not what's happening here. This is a Hobbs Act case.
And yes, but we believe that under the Hobbs Act, we participated, and according to DC Circuit precedent, that participation should be recognized, making us a party.
Okay.
Well, thank you. I'll reserve.
Thank you, counsel. Mr. Michael?
Good morning. I'm going to raise it. Sure. Good morning. May it please the court. This is a case about the NRC's decision to authorize a discrete, time-limited uranium enrichment project at the same location where the NRC previously authorized a significantly larger enrichment facility after preparing an 1,100-page environmental impact statement. Now, the petitioners have brought this Hobbs Act petition for review because they believe that this project is significant enough to warrant another environmental impact statement, but they voluntarily bypassed their opportunity to raise that argument before the NRC using the appropriate and available agency forum, which would be intervention in the underlying proceeding, an opportunity to which they are entitled by statute to pursue, and becoming a party in accordance with the agency's longstanding rules of procedure. That is the path that the petitioners were obligated to take if they wanted to preserve the possibility for this court's review and to properly exhaust their claims before the agency. That is the required path that Congress forged for them when it wrote the Atomic Energy Act and the Hobbs Act the way that it did. That's what the statutes say, limiting this court's jurisdiction to final orders of agency proceedings, and only parties aggrieved by those final orders may bring the Hobbs Act challenge. That's what this court has repeatedly said in Hobbs Act cases like ACA International, Water Transport Association, Simmons versus ICC, all cited in our brief, where this court has made clear that where intervention is a prerequisite to participation, that is the path you must take in order to bring the case under the Hobbs Act. And that's what the NRC's regulations say. They're unambiguous on this point. How does one become a party to an NRC licensing proceeding? You submit a written request for a hearing that demonstrates you have standing, and then includes at least one admissible contention. Now, I'm happy to address any questions the court may have on the merits of this case. What I'd like to do this morning is to focus on this jurisdictional question, because I'd like to elaborate for the court why this is such an important issue for the NRC. Because by asking the court to dismiss this petition for review, what we are really doing is asking this court to preserve the integrity of the NRC's administrative process and the hearing procedures, and preserve the necessity for would-be parties and petitioners to follow those rules. Our concern here is bigger than this one case. If the petitioners here are permitted to seek judicial review under these circumstances, then it would call into serious question what purpose, if any, the agency's hearing procedures would continue to serve if they can be bypassed ultimately without consequence. I think there are a number of NRC litigants who have played by these rules in the past who would be surprised to learn that all along there was a side door to judicial review that did not involve going through 10 CFR Part 2. Because that's what this case really is. And I think the reply brief exemplifies this. This is an attempted bypass around 10 CFR Part 2. Because the petitioners here do not like those procedures, and they think that they're too strict. And that's I can address that in just a moment. But Congress tasked the NRC with the statutory obligation to make hearings available when it engages in licensing decisions. And the contention admissibility standards in Section 2.309, which petitioners here object to, that is a deliberate policy decision by the Commission about how best to fulfill this statutory mandate to make hearings available.
Can you go to the question of whether they're too strict? Because I take it that agency doesn't have an agency does not have limitless authority to define the extent to which a party that's in fact an entity, I won't use the word party, an entity or organization or individual who's in fact affected by regulatory action wants to bring their grievance before the agency. The agency can't say, well, you can do that, but you have to do it on leap day, February 28th, February 29th. Got the count wrong, February 29th, right? Because then there's no opportunity at that point. So there's some constraints on what an agency can do.
Absolutely, Your Honor. And to be clear, to respond to this point that my friends on the other side made, it is not our position that whatever the NRC puts into 10 CFR Part 2, however we define party, that is binding on this court, full stop. That is not what we're saying. This court has repeatedly over the years recognized the validity of the agency's hearing procedures. This goes back to at least as early as the 1990 Union of Concerned Scientists decision, which is cited in our brief. where there was a facial challenge to these very regulations, facial challenge that they were not consistent with the AEA, that they were not consistent with NEPA because of the requirement to bring NEPA contentions through the NRC's process as well. The court upheld it there. This court has upheld, or at least tacitly implied, the validity of these regulations throughout the years when it has heard Hobbs Act petitions, challenges to NRC final orders where the NRC has enforced these standards, and the court has upheld those challenges as reasonable. So no, it is not limitless, Your Honor. If the agency views its discretion somehow or find party in a way that was arbitrary and capricious, of course, this court would have the opportunity to step in. But what we're saying is under the Hobbs Act and under this court's many decisions interpreting the Hobbs Act, where the court has said, if intervention is a prerequisite, you must intervene in order to obtain Hobbs Act review.
Suppose they wanted to bring a freestanding action under NEPA only, which frequently happens, as long as you can meet the Lujan standing requirements. That's the hypothetical in Lujan. A person who is potentially affected by the action in question and does not think the agency followed NEPA can simply file suit to challenge the agency's NEPA determinations. And they say, in answer to your question, let's assume you raised it, you're really challenging the licensing. They say, no, we're not. We're challenging the NEPA determination, which is impermissible under the law, and we have standing to do it because we're affected parties, as in Lujan. We would be affected by this, and we're challenging. Can they do that?
I think, as the petitioners themselves recognize on page 1 of their brief, this court has exclusive, well, not this court, the courts of appeals have exclusive jurisdiction to determine the validity of agency orders.
You're not sticking with my hypothetical.
Well,
They're not going after the relicensing order. They're going after the alleged failure of the agency to follow NEPA, which is not an unknown lawsuit. NEPA is an APA cause of action. That has nothing to do with the Hobbs Act. It has to do with, it's an APA cause of action, and parties bring it. Now, there's a question. Does that mean you go to the district court? Can we disconnect from Hobbs, and can they raise the NEPA claim?
I do not believe we can bifurcate the AEA aspect and the NEPA aspect. To the extent in your hypothetical, the question is, could they go to the district court and raise a standard NEPA challenge?
And you say you don't think so. Why? Is there some case law you found?
It's because the Court of Appeals under the Hobbs Act has exclusive jurisdiction to determine.
They're saying we're not under that. Let's assume we're not challenging the licensing. We understand there was a licensing. We're challenging the agency's alleged failure to follow NEPA.
But that challenge in your hypothetical, Your Honor, that challenge, if it went to district court, they would still be challenging whether the license was properly issued. NEPA itself does not provide for its own cause of action.
Yes, it does.
Well, I respect
it. Absolutely does. Do some research. That's clear. I mean, I was curious about this. It's an odd posture, and I spent a lot of time looking it up. NEPA absolutely is an APA cause of action.
APA. But then the APA has the cause of action, not NEPA itself.
Right. Yeah.
Right. And Your Honor, that would be an answer to your hypothetical. I think if someone brought that challenge in the district court,
right.
So we're not challenging under the AEA, we're just challenging under NEPA.
Right.
The claim, and again, we're in hypothetical territory here. The claim, I believe, that they would be presented there was, we are the NRC, when it issued the license, it acted arbitrarily and capriciously because it did not follow NEPA. That would be their
yes.
argument.
No, that's what I meant to pose. If I misstated a couple of the statutes along the way, I'm sorry. That's exactly what I'm posing as a hypothetical.
And if that is the challenge, then I believe we would argue is that should be brought in the courts of appeals, because at the end of the day, that is a challenge to the validity of the agency's decision to issue the license, and under the Hobbs Act, the jurisdiction to determine the validity of agency orders.
So you're saying they can't get out from under the Hobbs Act?
I'm saying that in order.
In other words, I mean, you could make the argument of the APA. They have an alternative remedy, and therefore they can't use the APA in the Hobbs Act context. That's a possible argument. Is that what I'm just trying to understand how you're setting this up in your mind, because there are many, many NEPA cases that simply arise under the APA. And yes, the claim is it's arbitrary and capricious and impermissible, inconsistent with what the law requires because it didn't follow the commands. And that was the hypothetical in Lujan, which was a standing case. The courts have always understood that's possible to raise that NEPA challenge under an APA cause of action.
And I apologize if I'm repeating myself in trying to.
You're saying they can't disconnect from Hobbs in this context. That's your argument.
That is our argument. This court has exclusive jurisdiction to determine the validity of agency final orders in licensing proceedings. Court has no further questions.
I have a question about the letter you all submitted about the extension going just another 2 months. We don't have a mootness problem. Nobody's mentioned it, but this enhanced 235 goes to 2037. Is that right? Or
I'm sorry, could you repeat, were those years that you're
well, the contract, as I understand it, goes through 2037. This demonstration program ends in 2 months.
I don't believe, and perhaps my
Okay,
but just to answer your question about mootness, and we submitted the 28J letter to at minimum alert the court that when it saw May 31st as the expiration date in the record that it had been extended. This is on paper. This is certainly a continuing dispute because the license authorizing activity is valid through November. What will happen beyond the end of November is unclear, and if there are any relevant updates, we will certainly.
But does it become moot at the end of November?
It depends on a number of factors that are unknown at this point, Your Honor. The contract expires in November. The agency's licensing, the authority to engage in the project under the NRC's license expires in November. If the interveners here, if the contract is extended, if they come in and submit a request to the NRC to extend their authorization to go beyond November, they may be asking to extend the exact same project. They may be asking to say the Department of Energy wants us to do something bigger, smaller.
What goes on until 2037? The contract under the 10% uranium-235?
I believe what Your Honor is referring to is so they have a license to construct and operate a large-scale commercial facility enriching only up to at maximum 10%. And that they haven't built it, but that license, the authority for them to do that goes through 2037. This case is just about this discrete, initially 3-year, now 3.5-year project where they say, well, we would like to enrich up to 20%. The license says 25, but they're not permitted to extract anything above 20. But this is a discrete 3-year project that is a 3-year authorization. And currently, that expires at the end of this November. Their authority to enrich above 10%, but that is unclear at this point beyond November whether or not the project will expire, whether it will continue in the exact same form, whether they will request authority.
Well, why doesn't that raise a mootness question then? Because what the petitioners are upset about is the enhanced uranium-235. And that stops in 2 months.
It currently, if not, it's status quo, if nothing else changed, the license amendment, the authorization would expire at the end of this month. But we recognize there is at least still the possibility that it could be extended again. If it were to be extended again, we would have, would there necessarily be a request to the NRC to further extend it? And depending on what that request looks like, we're requesting to extend the status quo another year or what have you. We're extending to do something larger. It will depend.
Would these petitioners then have to satisfy the aggrieved parties requirement if you do extend it, or before you extend it, actually?
Again, I think it depends on if there is an extension request, what does it look like? Are they just asking to extend the status quo for another short period of time? In which case, I don't know how mootness plays into there. We have this capable repetition, yet evading review mootness exception. If they're coming in and saying, forget the 3-year HALU project, we want to do something much bigger over a longer period of time. Here's our new license application. If that's something that is going to require a new NRC review, then they would, in my view, need to come in again.
So can you say whether whatever is coming after November will require a new application?
It will require a new application to go beyond what is existing.
All right.
And whether that requires new environmental review, it will depend on what they're asking, which at this point is unknown.
Okay.
And so they could seek intervention at that time.
Certainly.
And then for mootness purposes, even if we do get to a circumstance in which it might be moot, we still have the alternative route of the Hobbs Act, because we could we have a choice as to if we thought that there wasn't jurisdiction under the Hobbs Act because challengers are not a party aggrieved, we wouldn't have to do mootness first.
Correct.
We have a choice about which route to go if that's the conclusion we came to.
Correct. You could dismiss on jurisdictional grounds today, Your Honor. They're not parties aggrieved as of the time they filed this.
And we could also dismiss on Hobbs Act ground even after we're hypothetically to become moot. If there's still a Hobbs Act problem, there's no requirement if it were to become moot, there's no requirement that then we dismiss it on mootness grounds as opposed to on non-party aggrieved status grounds.
I don't know that there's a requirement, Your Honor. We would take dismissal either way.
I assume you would, but right, okay.
If there are no further questions, thank you.
Thank you, counsel. Mr. Fagg.
I'll use my brief time, I guess, to do two things. One, address as best I can the questions about the sort of current status, and then secondly, talk about some of the questions the judge was raised, NEPA and alternatives. And on the current status, and again, with apologies for the sort of uncertainty here, but often when you deal with the Department of Energy, it's one step forward, two steps back. But essentially, what government counsel said is correct. It was extended from May to November. It may well be extended again, and that's. But in terms of the amounts,
what's being extended? This demonstration program?
Yes.
Okay.
Yes, Your Honor. And I think counsel correctly described it. There is a sort of existing license for a massive plant, 11,000 centrifuges. This is 16, and these are things that spin, and they just spin a little longer and enrich the uranium. And so that's what this demonstration project is about. Currently, like I said, between now, work is going on the ground now to install these things, and they're measuring that against the license. So as we stand here today on October 13th, it's not moved. Things are happening. What will happen after November 30th, again, with apologies, is a little bit up in the air as we sit here today, because the Department of Energy may or may not issue another RFP. There may or may not be increases to the amounts. But there's no indication it's going to be massive. But again, the final point, if it is a significant or material change beyond what has been scoped by the NRC, there's another option.
Well, what I don't understand is if you're not doing something about it now, I mean, do you think you'll finish all this by November 30th?
Well, what's going on now, and I want to be clear, my understanding, from my client is that they're not enriching the stuff now. So they're not actually dealing with, it's all the preparatory work that's going into putting the equipment in place. And so that the enrichment itself, as I understand it, is not going to happen between now and November 30th. So obviously, I think it's safe to assume there's going to be some sort of time extension, if not.
Well, if you all are building a centrifuge, and I don't understand about this cascading or whatever, I don't think I need to, that is geared to the enhanced uranium-235. You're building it, but you don't know whether you're going to be able to.
Well, there's clearly an expectation.
235.
They're not doing it, with apologies for the uncertainty, but there's clearly an expectation that they're going to do it. That's why they're doing it. They're not just doing it because it's completely unknown. So I think that's another factor that sort of plays into why we don't think, we have an interest in this current amendment to the license and why it's not moved. But I want to be careful because I don't want to misrepresent the court. I don't want to say for sure that it's going to happen because I don't know what the Department of Energy is. And they're the ones who own this stuff, and they're the ones who are going to sort of grant the contract. So that's the best, and again, with apologies to the court, that's the best I have on current status now, and we would reiterate the government's desire if material things happen. I also agree that jurisdictional dismissal is sort of separate and apart.
What did you have to say about the APA cause of action?
And I think the answer to that, Your Honor, is what's the final action? Okay? And I think the government takes a position, and we agree with it, that an environmental impact statement or an EA is not a final action. It's not challengeable in and of itself, even in Lujan. It's challengeable through the APA as part of something that's going to become a final agency action. And that differs across different agencies. It differs across different review schemes. Here, that's where the exclusive jurisdiction of the Hobbs Act becomes relevant in step two. And so that's what I think distinguishes the situation where you might have some other sort of agency that's in a district court saying, we don't think, the environmental impact statement was sufficient, but that environmental impact statement, they're not challenging that. They're challenging the permit or the license or the lease or whatever that environmental impact statement went in through the APA in a district court action. That can't happen here with the NRC and with the. And so I think that's why.
Because the connection is to a statute that provides a remedy which would displace any request for a remedy under the APA, what you're arguing. The APA is not going to be available if there is an alternative remedy available.
I think that's fair.
And you're saying in the Hobbs Act context, that's the end of it, because you've got to go through the Hobbs Act. That's
yes.
really what
And this court, as government counsel said, has sort of reiterated that a number of times, going back to the Union of Concerned Scientists and Blue Ridge and all of those. So I see my time's up. Happy to answer questions. Thank you very much.
Thank you, counsel. Mr. Lodge, we'll give you 2 minutes for rebuttal.
Just like to remind the court that the Rayblatt decision from the circuit essentially held that commenting in a rulemaking context confers party status. Also, the Gage decision, Gage v. Atomic Energy Commission in 1973, the DC Circuit stated that the Hobbs Act applies to proceedings where the public can participate only by commenting. We believe further that the Massachusetts v. U.S. decision, which was a 2008 First Circuit determination that we mentioned in the brief, recognized specifically, explicitly, NEPA commenting is a means of participation as a party, and noted, the First Circuit noted that the NRC, quote, has not defined the term party uniformly in its regulation. I'd also like to correct something that my colleague from the NRC indicated, and this is one of the reasons for our particular outrage at the way the NRC conducted this licensing proceeding. The scope of the project as defined in the environmental assessment is actually a 13.5-year contemplated project. There is the 3.5 year initial startup period, more or less a demonstration type of effort to see what the feasibility is, and I'm sure many technical tests would be confirmed or denied in the course of that kind of centrifuge development of HALEU. However, it is very clearly stated as the scope of the licensing that Centrus contemplates an additional 10 years of ramping up incrementally as market demands require to full-scale commercialization. So this is a 13.5 year pivot into an entirely new fuel type. You heard the NRC admit that right now the constraint is 10% enrichment. The constraint in the new license, I believe, goes much higher than the even the 25% that is admitted might be a possible production problem. Thank you.
Well, let me ask you, Mr. Lodge, have you given any thought to when November 30th rolls around, if, and I'm not clear on what would be needed, but if something further would be needed, and another amendment to the license, something like that, have you given any thought to how you would challenge that?
Well, we're happy to have come all the way to the District of Columbia to learn that piece of information this morning, Your Honor. We certainly will be looking
well,
at...
let me say, assuming you're not an aggrieved party now.
Well, we're certainly going to be monitoring things closely, and if the result in this court is adverse to us, we will be pursuing our options, possibly under the AEA as well as NEPA. But we firmly believe that NEPA is its own separate independent track, well established by this circuit.
Well, you may want to look without regard to what we're doing at the moment, because our opinion may not come out at the same time that additional proceedings happen here.
Thank you.
Okay.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 21-5203, Valancourt Books LLC, Appellants versus Merrick v. Garland, Attorney General, and Cheryl Perlmutter in her official capacity as the Register of Copyrights of the U.S. Copyright Office. Mr. McNamara for the appellant, Ms. Meyer for the appellees.
Good morning, counsel. Mr. McNamara, please proceed when you're ready.
Thank you, Your Honor. May it please the court. This case began when the government sent Valancourt Books a series of demand letters threatening it with tens of thousands of dollars in fines because it had published books with copyrightable material without providing copies of those books to the government for its own use. That demand works at taking, and it violates the free speech clause of the First Amendment by imposing a burden on protected speech. And it does these so clearly, apparently, that the government expends most of its energy running away from the plain language of its own demand letters and the plain language of the underlying statutes. The government instead would have this court focus on its new litigation position, announced for the first time in its summary judgment briefing below, that Valancourt can now comply with this demand by depositing e-books, electronic books, instead of physical books. And I don't think that e-books get the government out of the box here for at least three reasons. One, as to Valancourt's future activities, there's a huge voluntary cessation problem. There's been no change in law or policy or regulation. There's no barrier to the government tomorrow demanding a physical copy of the next book, Valancourt.
Indeed, don't their statements indicate that they can switch back?
Yes, Your Honor, there's nothing to stop the government.
No, but I mean, isn't there a statement in the record that the government makes it clear that they can switch back to the hard copy? No guarantee that the electronic version will be the only requirement?
There is no guarantee, Your Honor. There's really nothing in the record about the government's position here at all. It just comes from their briefs. The only thing in the record is a confidential settlement offer that I think is not really properly before the court. But even if there weren't a voluntary cessation problem, as to the books the government's already demanded, the record also reflects that Valancourt can't provide electronic versions of all of them. There's at least a 5-year span where Valancourt no longer has the underlying electronic files. So as to those, we're still talking just about a demand for physical books. And even if this case were just about ebooks, and I don't think it is, a demand for ebooks would still work a taking and still impose a burden on Valancourt's First Amendment speech. I think it still works at taking because Valancourt sells ebooks. It sells them at retail. And so the character of the government action here is a demand that says that thing that you're selling at retail, give it to us for free so that we can keep it forever. I think that works.
It does look different, though. I mean, of course, you're making the argument that it's still a taking if it's if it's purely electronic, but it does look different because there's not the same scarcity issue with electronic documents as there is with a physical document. There's actually a transfer of something when it's a physical document. And so it would raise more complicated questions, it seems to me, under the takings clause, if we're talking about a purely electronic medium as opposed to a physical.
I do think it would be more complicated, Your Honor. I think that analysis still comes out in our favor. The question would come down to the extent to which the ebook, the file itself, is property. And I think it would be that states are a bit in flux on the status of electronic files, understandably. But the case law is clearly trending in favor of recognizing that electronic files are property. It can be trespassed upon, it can be converted, it can even be forfeited. And all those cases, I think, suggest that a demand for a particular ebook, even if you can make more copies of the ebook, is still a taking. But even if it weren't a taking, it's still a First Amendment burden. The record reflects that Valancourt would have to spend hours on regulatory compliance instead of on its core mission of publishing books. And the only reason it would have to spend hours on regulatory compliance is that it published books that contained copyrightable material. And publishing copyrightable material simply isn't something the government can punish. It isn't something to which the government can attach regulatory obligations.
Well, I mean, that's one way to analyze it, but why do you put publication and copyright together? They're inextricably tied, they're not. I mean, that's the favorable way for you to argue a case, but what we're really talking about, the Supreme Court said a long time ago, this is a government-conferred exclusive right. The only thing that's changed is now that the publication and copyright dates are the same. And in my mind, analytically, I'm struggling to figure out why that should make a difference. The court has already ruled on this. This is a government-conferred right for which they're making a reasonable request. deposit, and the Supreme Court has said, yeah, that's fine. And as I'm understanding your argument, the difference now is maybe this burn thing, which I think can't get you where you want to go, and also the fact that the copyright and publication are now on the same date. And my response to that in preparing is, so what?
Well, Your Honor, I think the difference here, copyright certainly is a government-created benefit, and the government could.
You don't start with it like the right to plant, in the case that you all keep arguing. It's more like Monsanto to me. You're not born with the right to copyright. You're born with the right to publish. That's true, but not with the right to copyright. And you only get that by virtue of the government conferring it. And the cases seem to suggest, at least as I'm preparing your side of the case, seem to suggest that the government can certainly condition.
I agree with you to a point, Your Honor. The government certainly can condition copyright. The government could adopt a statute that says copyright is conditional on depositing books or on paying a fee or on anything it wants. The key here is the government hasn't done that. Section 407 explicitly says that mandatory deposit is not a condition of copyright. And if it's not a condition of copyright, then it's not a condition on that government benefit you're discussing. Instead, copyright is automatic. The word the statute uses is subsists. Copyright subsists the moment a new idea is written down in any fixed medium. And that means that copyright is instantaneous. It's not offered in exchange. It's a background regulatory principle. The instant Valancourt writes a new footnote or a new author bio or asks a friendly academic to write a foreword to an old novel that it's republishing, copyright instantly adheres.
Well, we know that has to be the case because the government is making the argument that you can avoid the deposit requirement if you disavow the copyright. And you can only disavow a copyright if the copyright already existed. And the copyright existed at the moment of creation. So I think the government buys into the notion that there's a sequential dynamic going on here where copyright attached at the moment of creation. The publication, which may or may not come later, is what triggers the deposit.
I don't think disavowal really gets us anywhere here, Your Honor, for two independent reasons. One, there is no statutory mechanism for disavowing copyright. Copyright abandonment is a judge-created defense to a copyright infringement lawsuit. It's akin to lodges. It says, if you've acted like this isn't yours, we're not going to hear your claim.
Right. I know that you have your argument on how disavowal isn't a real option, and I think there's something to it, and want to hear from the government on that. I'm only making the point that the conceptual framework you laid out, there's no dispute about that, because the government's argument, I think, is a favorable point. The government's argument that your client can avoid the deposit requirement by disavowing copyright necessarily presupposes that copyright already exists.
That's right, Your Honor. And I think there's another thing lurking in the government's argument. The government doesn't acknowledge, which is the burden it's imposing. The way Valancourt operates is it will go to a friendly academic and say, will you write a foreword to this novel that we're repurposing and republishing? And the academic writes it and informally licenses it to Valancourt. And as I understand the government's argument, that transaction was illegal. That transaction should have been formalized where the academic could formally disavow the copyright, whatever process that entails, and the government has changed its mind about what that process looks like. Or Valancourt should have somehow publicly proclaimed that the academic didn't have a copyright. Our position is that it's perfectly legal just to solicit someone to write something and then publish that without attendant regulatory compliance burdens. And those regulatory compliance burdens are enormous here. There has been no dispute in the record that complying with the government's demands here would cost Valancourt endless hours of regulatory compliance. And as to the demand for physical books, thousands of dollars in collecting these books it doesn't even have.
Okay, can I ask you as a conceptual matter? I take it that you don't disagree that if the copyright laws existed as they did in the 1800s, that was a voluntary exchange, that the deposit requirement is voluntary exchange.
Absolutely.
So there's nothing wrong with a deposit requirement that's tied to the existence of a copyright.
I think that's right, Your Honor. I think maybe the best way to illustrate that is to contrast Section 407, which we're challenging, with Section 408, which we're not. Section 408 is the registration statute that says if you want to register copyright, something you can actually enforce in federal court, you have to exchange your property. You have to exchange a copy of the work. That's an exchange. That's a trade. And in fact, in Cedar Point, the Supreme Court specifically said that a license, permit, or registration is the kind of thing the government can trade.
So if to follow that through, if the state of the law beforehand was not a taking, and then what happens is Congress amends the law, so not to say that copyright arises at the moment of creation and the deposit requirement triggers at the moment of publication, but to say that that we're worried about the cost of the deposit requirement of it being the ultimate sanction of losing copyright protection. So we're going to impose a lesser cost, but it's still not something. It's not something that triggers only upon publication. It's still something that affects the existence of the copyright to begin with. That would still be a voluntary exchange of the kind that Monsanto said wouldn't be a taking.
I think that's probably right, Your Honor. If Congress in Section 407, instead of saying mandatory deposit isn't a condition of copyright, said it's a condition subsequent to copyright, that too could be seen as a voluntary exchange. The problem is copyright subsists automatically, and upon the act of publication, Valancourt incurs these obligations to provide copyright to the government. And I think that does go right to the heart of Monsanto. And Monsanto, the Supreme Court very clearly says, look, no one here has challenged that the government can just prohibit selling these hazardous chemicals, can license it however it wants. And so long as that's true, demanding property in exchange for the license isn't going to work a taking. But the government can't prohibit publishing books. It can't prohibit publishing books that contain new ideas in them. That is as fundamental as an American right that exists. And I think that's the problem with the government's position here. It's not a condition on copyright. It's not an exchange for anything. It's just a burden imposed on small publishers like my client in order to make sure the government doesn't have to pay for the books it wants. And I think that really illustrates the overbreadth problem with what the government's doing, is that to avoid paying however much it would cost for the books the government actually wants, it's imposed a burden on everyone who publishes copyrightable material. And the government, I think, has run away from the idea that this is a burden on copyrightable material. But that is the justification in their demand letters. That is still, as of this morning, the Copyright Office's explanation of Section 407 on its website. I checked this morning. It still says the law requires 2 copies of the best edition of every copyrightable work published in the United States. And what it gets is a flurry of books that it doesn't want. There's no question in the record that the government gives away tens of thousands of books a year, and that it destroys so many books that it cannot bother to keep count of how many it's destroying. All of this in service of just avoiding paying for things that are freely available for sale and retail, with the purpose of transferring the burden of maintaining a public library, which we concede is a valid public government interest, but transferring the cost of that from the public fisc onto the backs of publishers who have done nothing wrong beyond publishing copyrightable information.
If this was an opt-in scheme, is the result different in your view?
I'm sorry, Your Honor?
If copyright was an opt-in scheme?
Unquestionably, Your Honor.
Unquestionably what?
If copyright were an opt-in scheme, the government could condition it on any sort of reasonably tailored condition it chooses.
So that's your answer to my starting question. When they put the two together, they're effectively regulating the right to publication.
That's exactly right, Your Honor. You combine automatic copyright with obligations that come the instant you publish automatically copyrighted material. What you've done is make it illegal to publish a book without fulfilling your attendant regulatory obligations. And that violates both the First Amendment and the Fifth.
Can I ask you, we will give you some time for rebuttal.
Thank you, Your Honor.
As between the First Amendment claim and the takings claim, put aside the First Amendment claim that has to do with enforcement, because it seems to me the remedy, if you were to prevail on that, would be different, because that's just to end the enforcement practice that raises the question.
I agree.
But under the broader First Amendment argument, which is that even if you assume it's content neutral and you just go to the statute, is there a difference between the takings claim and the First Amendment claim?
I think the only difference, Your Honor, is to the extent the court decides to address the ebooks question, the burden on the publisher is roughly the same, whether they have to go through compliance to deposit and record the deposit of physical books or electronic books. And it might be easier to resolve the case on the First Amendment basis, because then I think ebooks fall out entirely. You don't have to address my argument about whether a demand for an ebook or a piece of software or a subscription website is a taking, because the only question is whether it's a burden on the publisher.
Right. Okay. So then in terms of physical copies, let's just assume we're just ignoring ebooks altogether. in terms of physical copies, is there any difference?
I think they work the same, and I think the district court's analysis largely worked the same, where it rejected our takings claim on the theory that this was an exchange, this was a condition, and then it rejected our First Amendment theory on the grounds that the government can impose these burdens because this is an exchange, it's a condition. Once the conditional nature of copyright falls out, I think we prevail on both for, frankly, largely the same reasons.
And then the flip side is also true. So, for example, under 408, which you acknowledge is a voluntary exchange of the kind that doesn't affect the taking, it also therefore doesn't affect any First Amendment problem.
Absolutely. Under 408, you're free to publish anything you want. You just don't get the special government benefit of an enforceable registered copyright, and the government is free to do that without burdening protected speech.
Make sure my colleagues don't have questions for you at this time.
No.
Thank you.
Very much, Your Honor.
Myron?
Thank you. May it please the court, Laura Myron for the government. The demand requirement has been in the fabric of copyright law since the founding. The Supreme Court upheld it in Wheaton. And the only question before this court today is whether the changes Congress has made since and make it easier for copyright holders to get and maintain copyright protection have somehow rendered it unconstitutional. As a practical matter, for most copyright holders and owners of the exclusive right to publish, the exchange works exactly the same way that it did in Wheaton. The government confers the benefit of copyright protection, which allows you to publish your work with the exclusive right to disseminate and distribute copies. It allows you to put in the front of the book, as plaintiff has, a notice that says any use, copying, publication, whatnot of this work shall be a violation of federal law. And it allows you to register your copyright if someone, notwithstanding that threat, infringes on it and copies your work, and sue them for injunctive relief, in exchange for which most copyright holders are happy to send the government 2 copies. Plaintiff would have you believe that because copyright protection now adheres at the moment of creation in the work, because which Congress did in order to make it easier for people to secure copyright protection and more difficult for them to inadvertently forfeit it by not correctly publishing with the right notice, that somehow copyright protection has become an unalienable right that you can't get rid of if you don't want to comply with the deposit requirement. That's simply contrary to the way courts have understood copyright for decades. It is well established that you can abandon a copyright. It's true that in the cases that have come up, it's a little bit murky because usually the question is presented to the court in the context of someone who's suing to enforce their copyright protection. It's significantly easier in the context of 407. Any overt act.
Can you win on the takings claim if there isn't a robustly available, what you're calling abandonment option?
I think that's somewhat of a counter hypothetical, that it is clear that you can abandon a copyright. It would be astonishing for this court to
Right, so could you win if that didn't exist? And then we'll get into whether it in fact exists. But could you win under on the takings claim if there wasn't a very readily available way just to say, if you're a publisher, I don't care about the copyright.
Well, look, the Supreme Court said in Wheaton that when the legislature is about to vest an exclusive right in an author or inventor, they have the power to prescribe the conditions on which the right shall be enjoyed. So I don't disagree that it might be a tougher question, but I do think that Wheaton would still conclude that this provision would be constitutional. And again, for purposes of 407, setting aside whether or not the Copyright Office doesn't comment on whether any overt act that manifests an intent to abandon copyright is sufficient for infringement purposes. But for purposes of 407, any overt act would suffice, including responding to the demand letter saying, I do not want my copyright protection in this work. If counsel for plaintiff were to stand up on rebuttal and say, as a representative of the plaintiff, I am authorized to indicate that that the plaintiff is foregoing copyright protection in the demanded work, that would take the plaintiff out of the statutory provision, which applies, and this is from the text of 407, only to the owner of copyright or the exclusive right of publication. So if you abandon your copyright, you are no longer the owner of copyright, and the requirement in 407 does not apply to you.
Why is this nowhere? You can't. This has never come up other than in the briefing in this case, as far as I know. This
Yes,
idea.
Your Honor, because nobody, as far as we can tell, wants to give up the benefits of copyright protection, which are myriad. You have the Association of American Publishers as amici in this case telling you that giving up copyright protection would be economically devastating for the publishing industry. So it's true that it doesn't come up very often that somebody wants to abandon their copyright and is unable to do so. I mean, there are certainly people who publish works, with disclaimers that say this work is not subject to copyright protection, copy, as you like. But it is true that it doesn't come up often outside the context of infringement litigation because by and large, copyright is very beneficial for copyright holders. It extends, as I mentioned, a litany of benefits, including the right to exclude from publication of the work, the right to control the dissemination of your work, to profit from publication thereof. And the Supreme Court has recognized that it's an economic driver of the publishing industry and that it promotes creative expression, it promotes the things that the Copyright Act is intended to protect, and that it's reasonable to condition the exchange of that very valuable government benefit on the submission of 2 copies of the work.
And you think that the freely available disavow abandonment, to the extent that someone could just stand up in court and do it, that's consistent with the statute that says that copyright protection subsists?
Yes, Your Honor. I mean, the plaintiff is asking you to read that statute to say that somehow copyright protection, because it adheres a publication of the work, even if you don't put the requisite notice in, that somehow it has become an unalienable property right. That's anathema to the way we understand property law. Certainly, there isn't any indication that Congress's use of that language was intended to make it so that no one who didn't want copyright protection could abandon it. And plaintiff has brought both, I think it's important to note, a facial challenge and an as-applied challenge. There's certainly no question that as applied to the plaintiff, if they wanted to abandon this, the government has said this both in this litigation and elsewhere, if copyright protection no longer adheres to the work, if you are no longer the owner of copyright or the exclusive right of publication, that 407 would not apply to you. So the statute as applied to plaintiff certainly wouldn't be unconstitutional in that regard because they have not sought to abandon their work and been unable to do so. And as a practical matter, as I noted, the vast majority of publishers do opt in, do want to maintain their copyright protection, even when faced with a demand letter.
Now, you mean they don't opt out?
I'm sorry, Your Honor?
You mean they don't opt out? But they do opt in, not opt in.
They
Get it automatically.
You get it. Well, I mean, their argument is essentially forced to take. And I think what they're saying is the forced to taking is really a regulation of a right to publicate, to publish.
So if I could, I think to say 2 things in response. The first is we usually think of takings as instances in which you have no choice but to comply with the government's demand for your property. You might be able to get compensation from the government for turning over the property, but you don't have a choice to say, actually, I don't want the government benefit that you're offering, and I don't want to comply with the demand, and so I choose not to do so. The second is that, as I said, they're suggesting somehow that the fact that the copyright adheres to the work at the beginning makes it unalienable, and that simply can't be correct. And as I said before, I suppose even if you were concerned that there was somebody out there who did want to abandon their copyright and was unable to do so, that might give rise to a particular as-applied challenge in which you could consider in that circumstances of that case, whether there was a constitutional problem. But certainly that's not the plaintiff you have before you today. And the plainly legitimate sweep of the statute is broad enough, as I said, the vast majority of publishers do want the myriad protections of copyright in order to deal with the plaintiff's facial challenge.
What about the notion that there's a $125 fee for abandonment, at least in some contexts. Is that just not a thing?
Well, the $125 fee goes with recordation of a document, Copyright Office, which we have noted is a way that you could abandon your copyright. It's certainly not the only way. The government has never said that's the only way, and that would be contrary to decades of case law that say any overt act manifesting an intent to disclaim a copyright suffices for purposes of abandonment. And certainly,
so why does that option? Why is that even? Why would anybody take the $125 option if you have a free one?
I suppose. I mean, I don't want to guess, but I suppose there. If you wanted to address both the question of abandonment for purposes of 407 for the Copyright Office, and also more publicly for purposes of future infringement, copyright, whatnot, that would be available. That's the recordation fee applies to any document that you would record with the Copyright Office, so it's not just for cases in which someone wants to disclaim their copyright. It's just a mechanism for engaging in an overt act.
As a neutral listener, that's a very strange answer. Why would I ever want to pay $125 if all I want to do is say I don't want this thing? You say I was born with it, and as soon as I publish, I'm stuck. Stuck meaning the least I have to do is give you $125 to be unstuck.
Certainly, Your Honor. I apologize if I was answering a different part of the question. You don't have to do that, and as far as we know, people don't do the recordation as means of abandoning copyright. It is an available option if you wanted to, an answer for how to manifest an intent to abandon. You could file something with the Copyright Office. But as I said,
it's like going to the registrar of deeds in a county for property. You're just saying this is one way you can technically do it in order to get it recorded for time immemorial, and someone can go check and they can see that.
Yes,
but if you just want to disavow it without worrying about whether somebody could check on it, you can do it for free.
Yes, Your Honor.
And how do you do that?
You could do a number of things. Any overt act manifesting an intent to disclaim copyright, you could respond to the Copyright Office and say, I do not want the copyright in this demanded material.
Who does it go to? Does it have to go to? I mean, if you just send an email to your friend saying, I wish I didn't have a copyright.
The Copyright Office, in order to, retract the demand letter, would need to be made aware of it. But in response to a demand letter, if you write an email to the Copyright Office and say, I have disavowed my copyright, I have abandoned my copyright, the Copyright Office respects that for purposes of 407. And certainly that's within, a reasonable understanding of the statute of the owner or exclusive right of publication in a work in the United States. If you are no longer the owner or holder of exclusive right of publication, then for purposes of 407, you are no longer subject to the requirement. Again, plaintiff has never sought to abandon their copyright. In fact, they've done everything they can
I mean, of course they want to. I think everybody would want to retain the copyright if they can.
Yes, Your Honor, and I think that highlights that this is a valuable government benefit that you are receiving in exchange for the copies of the work in the same way that the court recognized in Wheaton. I would also point the court to the Supreme Court's decision in Washingtonian Publishing, in which the Supreme Court recognized that inadvertent forfeiture of copyright was a draconian punishment, and interpreted the timing provisions of the copyright scheme as the demand deposit requirement scheme as it existed at the time, in such a way to make it easier for copyright holders to satisfy the requirement at that time by interpreting it promptly.
If there is this liberally available abandonment option that can just take the form of an email to the Copyright Office, is that irrevocable?
The Copyright Office, respects it for purposes of 407. The Copyright Office doesn't take a position on whether that would be sufficient or effective for infringement litigation. It doesn't, say that with respect to any, overt acts manifesting an intent to abandon, because that's for courts to decide. But certainly for purposes of 407, if you are no longer the owner of copyright or of the exclusive right of publication, which you divest yourself of, as courts have said for decades, by an overt act manifesting an intent to abandon your copyright, that for purposes of 407, I think you would be done.
But how would anybody know? I mean, suppose if a copyright owner sends the email and then subsequently files an infringement action, what's going to happen with that email?
Well, they're publicly available documents. I suppose you could get it through a FOIA request. There might be a hard question of whether whether it's sufficient for purposes of infringement. But
right. I mean, if you pay the $125, obviously it's publicly available. But if you don't do that, if you just send an email,
it is a public record. It would be.
Someone would have to file a FOIA request in order to the subject of the infringement action would have to file a FOIA request to know whether.
I think there are two separate questions. One is the effectiveness of abandonment for infringement litigation, and the second is whether or not you've sufficiently taken yourself out of the exchange provided in 407. Right. And certainly for purposes of 407, the email would suffice, and that's enough to dispose of plaintiffs both as applied and constitutional challenges to that particular statutory provision. And certainly all of this, as I've said several times, is hypothetical realm because plaintiff has not sought to abandon its copyright, and as far as we know, hasn't pointed to anyone else that they think have sought to abandon their copyright and been unsuccessful in doing so. I suppose, as I said before, you might have a more difficult as-applied challenge in that particular case, but that case doesn't come up because most people want exchange being offered by Section 407.
Right. I'm just saying that if somebody can abandon it for purposes of 407 easily, and then it actually doesn't have irrevocability or permanent costs, then yeah, you could do that because you could just say, I'm abandoning it for 407 purposes. I'm not telling you whether I'm abandoning it for any other purposes, but at least this means that I don't have to send the demand copies.
Again, the Copyright Office doesn't only concerns itself with whether your abandonment is effective for purposes of 407. And certainly you could understand, as a constitutional matter, the language of 407 to mean that an owner or of copyright or a holder of exclusive right is someone who has not engaged in an overt act to abandon their copyright. And I think that's enough to resolve the question before the court today. There may be more difficult questions if that person were to turn around and try to bring infringement litigation. But again, the plaintiff hasn't done that. In fact, the plaintiff has done everything, in terms of structuring themselves as the exclusive right, as holder of the exclusive right of publication, of publishing the notice that threatens, that any use and copying of this work is a violation of federal law, and steadfastly refusing to abandon its copyright. And
can I ask you this question? So just shifting to the First Amendment for a second. So suppose that, just hypothetically, I know you'll resist this premise, but suppose that we don't give you the benefit of the liberal abandonment option that you're resting your takings argument on. And then it doesn't automatically transfer over to the First Amendment either, because that's also a principal force of your argument on the First Amendment is, look, there's no burden here because it's just voluntary to begin with. It's just like 408. What's the problem? And I think the opposing side agrees that if it were like 408, there wouldn't be a First Amendment problem either. But suppose we're not joining you on that. Then what's the argument if there's not the liberal abandonment option available? What's the government's argument as to why a burden imposed upon publication is valid, even putting aside content? Just suppose it's content neutral. It's just anybody, it applies to any content whatsoever, but it's still a burden imposed on publication. And it has to be justified by the government, even though the government could pay for the copies, even though the government is destroying, the Library of Congress is destroying, for totally understandable reasons, a bunch of books. It just seems like there's a benefit burden calculus that is difficult for the government based on what's in the record of this case, if you reject the threshold submission that you have, which is this is not a burden to begin with.
The requirement in 407 applies to the owner of copyright or the exclusive right. And the requirement that you deposit copies would still be a condition on which the right to copyright shall be enjoyed. Congress doesn't need to provide publishers with copyright. There's no background principle which you are entitled to publish with the protection of copyright. In fact, the Supreme Court in Wheaton noted that copyright is entirely a creation of statute. And so the demand requirement would still, the deposit requirement would still run with the benefit of copyright.
But it only triggers on publication. So it doesn't trigger on copyright, because copyright already exists no matter what. It only triggers on publication. And it just seems to me that it's a textbook First Amendment, at least a serious textbook First Amendment question, if there's a burden imposed on a party by virtue of publication.
Well, look, Your Honor, I think, some of what you're getting at is some of the tension between the copyright, the exclusive right of publication, the copyright scheme, and the First Amendment. And the courts have long recognized that copyright, which, limits the publication of certain things and, provides exclusive rights, is actually good for the First Amendment. They work in concert in order to, as I said before, bolster an economic market for publishing. So I don't think it's fair to read this as just an act on our burden on publication. And certainly that's because anybody could publish something that says, I do not claim, like, even if you set aside the question of whether once you've already received copyright, whether you can avail it, you can abandon it, excuse me.
Mm-hmm.
I don't think there's any dispute that if you publish something that says, this book is for public use, I am not claiming copyright, that would not be subject to copyright protection if you do that at the moment of publication. And if you do that, you can publish anything you want, say anything you want, without running afoul of, without encountering the burdens of 407, and then, of course, without running afoul of the First Amendment. And I would also note that India has not pointed to any speech or First Amendment activity that has been chilled by virtue of this requirement. They can't find anybody, as far as we know. The American Association of American Publishers has not come in and said, people are being chilled from publishing by virtue of these provisions of the Copyright Act because of the way copyright law operates. And it wouldn't be a First Amendment problem because it's a burden on, as I said, the provision or associated with the provision of this.
Make sure my colleagues don't have additional questions for you.
Thank you. If you would like, I'd be happy to address the court question in the supplemental order about per se versus takings, per se versus electronic takings.
On per se versus regulatory takings, if we have questions about that,
Thank you.
I don't, but
Okay. Thank you.
Thank you, counsel. Mr. McNamara will give you 3 minutes for rebuttal.
Thank you, Your Honor. Just two very quick points. First, I actually agree with my friend from the government that most publishers do want the benefits of copyright. And we know that because most publishers choose to register their copyrights under Section 408 and trade their books under 408 instead of depositing their books in exchange for nothing under 407. This is at Joint Appendix 118, but the Copyright Office gets more than 4 times as many books through 408 as it does under 407, because those are the people who want the benefits of an enforceable copyright. And second, just a word on abandonment. If abandoning copyright were easy, Your Honor, then the government would have been able to consistently describe the abandonment process throughout this litigation. It hasn't been able to do so. Its position below, the position adopted by the district court, was that we had to pay $125 to record our abandonment. There's nothing at all in the record to suggest the Copyright Office treats abandonment in the way that we were discussing this morning. Just absolutely nothing.
Well, let's assume they do.
Even so, Your Honor, if they did, I think that still creates a massive First Amendment burden. My friend from the government
Well, start with the taking thing first. Then I'm not sure I understand the taking order. Assuming abandonment is straightforward. Send an email. If they send you something saying you owe us something, you say, I don't want it, etc. It's straightforward. It's as straightforward as you can imagine. What's the takings claim?
The demand itself is still a taking, and the question is just how much effort we have to put forth to escape the taking. In Horn, they could have stopped selling raisins. Here, perhaps there's some amorphous process we could go through to abandon the copyright, but crucially, we can't abandon these copyrights because we don't own them. As I said before, a lot of the copyrights here are automatically attached to an assistant professor of English at a university somewhere in the country. To abandon the copyright, Valancourt would have to go to that professor and urge him to undertake whatever process the government has now decided counts as abandonment, file that with the government, and thereby remove the automatic copyright from the foreword of this book. That is a burden on Valancourt's First Amendment publishing activity. And I want to be clear on the
You keep
word.
going to the First Amendment, and I'm trying to get your position. If abandonment's not an issue, I don't see why taking.
I also think it's a burden to escape the taking, because in any takings case, there's something that you could do to escape the taking. Here, it's always been clear we could avoid giving our property to the government by paying a fine. Our position is that forcing us to pay a fine is too much of a burden. And I think
Or you cannot publish.
Or we could not publish. And we think forcing us to forego the right to publish books is too much of a burden. So too, forcing us to track down and enter into formal agreements with anyone who has ever created any written word for a Valancourt book imposes a burden. And so the demand for physical property is still a taking, and it still functions as a burden on our fundamental right to publish books containing new ideas.
Suppose, let's take the hypothetical. Let's assume I'm not going to get involved. Published, and if I get a request to pay a fine or whatever from the government, at that moment, I will write a note back to them saying, I don't want this. It's that easy. You don't have to do a single thing other than wait to see whether the government dares to say you owe them something. And at that moment, you say, I don't owe you anything because I don't want this copyright. I didn't ask for it. You say it was automatically there. I don't want it. And I'm not paying you a fine.
I still think there are two problems, Your Honor. One, that's contrary to statutory text that says our deposit obligations arise 3 months after publication. There's nothing to suggest we can retroactively eliminate them years later when we get that record. That's not the system Congress set up in the statutory text. And two, we cannot disavow things we don't own. What that system would say is that it's no longer legal to have these informal arrangements with people to write illuminating footnotes or interesting forewords. And yet, I think we have a fundamental right to have people write interesting forewords and illuminating footnotes without engaging in regulatory compliance. And I think the only dispute we have with the government here and what's shifting in the government's shifting litigation positions is the scope of that burden, is how much regulatory compliance we have to do. But if all we're doing is publishing books, if all we're doing is just exercising a right that's existed since Gutenberg, the government can't impose up. The only hope they have is that we said something new, that we said it in public.
So I'm trying to construct the hypothetical that avoids the complication you raise about somebody else's copyright. I take that point. So I understand the complication. But if we can construct the hypothetical where the demand requirement only kicks in where you're asserting your own copyright, and if that's freely abandonable, then is there a problem? Is there a takings problem?
I think in that hypothetical, I would say there is still a takings problem because you have to do something to abandon the copyright. I guess if we embrace
even if it's just sending an email.
Even if it's just sending an email, if I forget to send that email, I'm subject to fines. That's certainly a much smaller.
Well, no, but then when you get the follow-up notice saying you forgot to respond, and then you say, okay, I meant to tell you this last week, I'm telling you now.
So I think the strongest version of the hypothetical is an email that says, you have to deposit these books, and if you don't deposit these books, we will assume you have abandoned your copyright. That imposes no obligations on us. That's the easiest way to escape the taking. And I think that actually wouldn't work a taking. It doesn't actually demand the book. We can freely escape it. The only problem is it violates Section 407 because that turns...
Right, put that aside. Let's just assume the government has an interpretive room on that.
I think you're right, Your Honor. That wouldn't be a taking because that's not actually a demand for books on pain of either punishment or some other burden we'd have.
And then if you just flip it a little bit so that it's not, they don't put the onus, they don't assume that you're abandoning, but they just require you to do something trivial to abandon, which is, just respond. Like you get those texts that say, send them one if you want to keep your reservation. That's right. That kind of thing.
Yeah, I think at a certain point, Your Honor, there probably is a burden the court could say was de minimis. I can't offhand think of a takings case where the government said you can escape this taking by undertaking a de minimis burden. I would anticipate the Supreme Court would say that if the question presented itself. I just don't think we have a case of the de minimis burden.
Right. And then query what the compensation would be if really what the just compensation would be if there's really nothing to the burden. Exactly. But your main burden point is that there's copyright that's not yours to relinquish.
Yes, Your Honor. We have to have some formal arrangement with everyone who writes anything for a Valancourt book, which would be retroactively, it would be enormously burdensome tracking these people down. And on a forward-looking matter, it would require Valancourt, which is a two-man operation, to essentially have in-house counsel to craft agreements that make sure every author knows they are abandoning their copyright by publishing.
See if my colleagues have additional questions for you. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Stand, please. This honorable court is again in session. Case number 19-7010 et al. United States of America for the use and benefit of American Civil Construction LLC versus Hirani Engineering and Land Surveying PC, Colonial Surety Company appellants. Mr. Delaney for the appellants cross appellees, Hirani Engineering and Land Surveying PC and Colonial Surety Company. Mr. Browdy for the appellee cross appellants, American Civil Construction LLC.
Good morning, counsel. Please be seated. Mr. Delaney, please proceed when you're ready.
Thank you, Your Honors. May it please the court. We're back before this court for the second time to resolve the remaining issues that are left after an opinion and judgment from this court in June of 2020 that affirmed the United States District Court's judgment in favor of a subcontractor, finding that the proper measure under DC law for measuring damages was, for an express contract, was restitution damage.
Would you state the record which party you're representing?
I'm sorry, Your Honor. I represent the appellants, Colonial Surety Company. With me is Mr. Shore, who represents Hirani. He will not be speaking unless the court has any questions.
Thank you.
So as I was saying, this court previously affirmed the award of damages on a breach of contract restitution basis, finding that there was an express written agreement and remanded for additional fact findings on Colonial's first cause of act, first appellate point, which was whether or not the claim against the Miller Act surety was barred by the 1-year limitation period. We had our additional findings of fact. It didn't go Colonial's way. We have subsequently withdrawn.
I thought you withdrew that.
We did, Your Honor.
All right. So what's the next issue?
Well, the third issue that we're going to be withdrawing today has to do with the evidentiary issues, which related to.
The only issue is the damages award?
That's correct, Your Honor. On the appeal, there's one issue remaining on the cross appeal, but as for Colonial's appeal, it's whether or not the district court has found and this court has affirmed that breach of contract, an express contract, is the proper theory of recovery and has awarded damages on a restitution basis, whether or not it was reversible error for the district court to also stray into the quasi-contract realm and award quantum Merrick damages against the Miller Act surety. It's our contention that that is reversible error and that there is no
strongest authority.
There is no authority that supports what the district court what the district court did, Your Honor.
So what is your authority?
Our authority is that the Miller Act incorporates the general principles of suretyship, that a surety's liability is coextensive with that of its bond principle. That's the Johnson case that we cited. There are multiple Miller Act cases where the court says, yes, these general principles of suretyship exist in the Miller Act. All the Miller Act does is it creates effectively a mechanics lien statute for federal projects, and it gives those claimants who did work on those projects the right to pursue a surety. But in that surety, in recovering that surety, we have to determine which world we're living in, whether we're living in the express contract world or the quasi-contract world.
Well, the district court ruled on that. And what is wrong with its ruling? He said this is not in the nature of quasi-merit. It's an express contract. So this is a claim in the nature of restitution.
Well, the district court did both, Your Honor. The district court kind of has one finger in each pie. The district court said, as against Hirani, the proper measure of subcontract damages under the express contract is restitution, and this court has previously affirmed that. However, the district court then strayed outside the contract world into quasi-contract world and awarded damages on quantum merit against the surety more than triple the amount of damages that it had previously awarded against the general contract.
Well, I mean, for Hirani, it would reach a contract action under DC law, right?
Yes, Your Honor.
And for Colonial, it's an action under the Miller Act.
That's correct, Your Honor, but that doesn't change what remedies are available to, again.
I mean, it could conceptually, because you could have, I take it the question under the Miller Act is a question of federal law.
100% correct, yes, Your Honor. But the case law still says we still look to the subcontract, because the Miller Act, the idea behind the Miller Act is the reasonable value of labor and materials that the party provided to the contract. The courts across the country interpreting the Miller Act say you look to the express contract to determine what that reasonable value is. Where there's already been a determination that's been affirmed, yes, the contract exists, hasn't been repudiated, one of the various, it wasn't procured by fraud, something like that, where you would then leave express contract and go to quasi. Even under the Miller Act, you still look to the express language of the written agreement to determine what parties themselves determined the reasonable value of that labor and materials were. There are several cases in the record, including Metzger, which specifically said, the Ninth Circuit specifically said it's not the intention of Congress in enacting the Miller Act to go outside the scope of the underlying bond principles liability, be that in express contract or quasi-contract. There are times when quasi-contract is the correct measure of recovery, but it's against both entities. It's the surety and
you then, Hirani took the position before the district court that it was financially unable to pay. Is that correct?
That's incorrect, Your Honor.
Incorrect? Where
Incorrect.
did it tell the district court that it stood ready, willing, and able to pay?
It didn't tell the court that it stood ready, willing, and able to pay, nor did it tell the district court that it lacked the ability to pay. That is...
In ACC has quoted language in the record about Hirani's financial situation and that it was unable to pay. It's
Judge, that it's not in the record. The only document in the record.
He quoted it. I mean, if it's a misquote, that's one thing, but it is in the record.
Judge, the only document that I'm aware of in the record is a document that Hirani gave to the surety after the bid results were released, in which case Hirani substantially underbid the contract. And in order to permit the surety to step in the event Hirani fell down and couldn't complete, because the surety provides not just the payment bond that ACC is suing under in this case, the surety also provides a performance bond to the government. And if the surety were to interfere with Hirani's contract with the government, it could conceivably open itself to tortious interference with contract allegations. So in order for the surety to issue the final bonds, it required Hirani to send a document to the surety that effectively said, we lack the ability to finish this contract. We want the surety to go in. That's the only reference. That's the only.
What's wrong with that?
I just explained the context of that, Your Honor. Hirani is a functioning company to this day that's still bidding on and performing public work.
Well, that's after the fact. We're talking about the record that was before the district court when it ruled. And you just quoted the language.
And I also explained the context of what that document was for, Your Honor. There was no testimony on that point. And frankly, that's immaterial to the court's analysis. Where
before this court have you said Hirani stood ready, willing, and able to pay?
I've never said it, but frankly, Judge, it's not an issue. I know that the
respect, you're saying the surety should not be, its liability should not be coterminous with that of the prime contractor, correct?
No, Judge, the contrary. The surety's liability is coextensive with the general, its bond principle, the general contractor's bond liability. The problem here is that.
You're playing with words here, counsel. As I understand.
Not at all, Your Honor.
With all due respect.
Not at all, Your.
With all due respect. Let's assume you're not playing with words, but nevertheless, it's well, Mr. Bode can clear this up, I assume, by the record, but I don't understand. If it's coextensive, then the only question is what? Does it owe anything, or does it only owe what Hirani failed to pay to ACC?
But thank you, Your Honor. I see my time is almost up. Can I answer Judge Rogers? Thank you. To answer your question, Judge Rogers, the surety's position is not that we don't owe ACC. We owe ACC zero. There's already been a determination, excuse me, under the existing subcontract. So it's the surety's position that the basic principles of surety law, which also apply through the Miller Act, are that the surety's liability is coextensive with Hirani's liability. The judgment against the surety should be $586,000 and change, not the $2-point-something million entered by the district court on a quasi-contract theory.
Thank you.
Thank you, Your Honor.
I have one question for you.
Yes, Your Honor.
It's just shifting gears for a second.
Sure.
There's the argument about the statute of limits, and then there's a related argument about hearsay, double hearsay. Yeah. And I just want to understand your view, because argument one, you're no longer pressing.
Correct. Based upon what happened with the remand findings, we weren't going to win. We withdrew it. In preparing for today, I realized we also have to withdraw the evidence question, because those rulings dealt with documents that were being used by the plaintiff to show what their last date of work is.
Okay.
If that issue's out, the evidence issues have to come out as well.
Okay.
I apologize for not discovering that until the last minute, but this is my first opportunity to withdraw.
So we can take your statement at this point as saying that you also withdraw issue the 3 or 4. I can't remember which one it is. 3.
Great.
So you also withdraw issue
1's
3
out, 3's out, 2 is in. That's the divergent award.
Yeah. But 3's out.
Out.
Okay. All right. Wanted to clarify that.
Any more questions?
Thank you. I don't think we have questions at this point. We'll give
Judge
you a little
Rogers?
rebuttal time.
Thank you.
We'll give you a little rebuttal time. Thank you, counsel.
Thank you.
Mr. Brode? I think you're on mute. Or at least we're not able to hear you.
We can't hear you.
We're still unable to hear you. Let's see if we can clear that up. Is not, did we test it earlier and it worked? Okay. Let's try one more time. Still not working. Why should we take a...
I'm trying to call Mr. Browdy, but I believe Mr. Browdy is also trying to call us, so the line is busy.
Okay, you think we should take a short recess until we get the connection established?
We can take a recess. Would you like me to call it?
Why don't we do that? Why don't we take a short recess until we get the connection reestablished, and then pick up with Hirani's argument.
Stand, please. Stand, please. This honorable court is again in session.
Please be seated. Mr. Road, I believe. Hear you now. Yeah, we can hear you now. Thank you. Please proceed.
Can you hear me now? Thank you for allowing me to appear remotely. I'm sorry for the problem. All right. To answer Judge Rogers. The Hirani on supplemental appendix 1102 stated they were insolvent. Colonial took over all payments and made or didn't make all payments under their escrow account, right? So the fact that our client, American Civil Construction, wasn't paid from from November of 2011 through termination was because Colonial didn't pay him. Colonial controlled all the payments. Hirani is in fact a broke. They have a different company which sounds like Hirani Engineering, because we've looked at that, run by Jim Hirani's son. As far as we know, that they've always remained insolvent. But that's neither here nor there, but that does answer Judge Rogers'
Well, of course, counsel for Colonial argues, quote, the context, close quote, of the statement to which you are referring as not quite indicating what you're saying. My question here, though, is when the district court entered awards of $2,568,000, was it clear from the judge's order those different amounts and the theory underlying them?
Yes. What Judge Mehta was finding is that amount that was awarded included all the change orders. If you go to the takeover agreement that was signed between the government and Colonial, they recognized there was $800,000 of change orders that went into the Colonial pot for a payment. Also, there is a letter written by Eric Hirani in the response to the show cause letter dated February 25th, 2013, written by Hirani Engineering, saying that there were approximately a 2-year delay because of 77 change orders that was issued by the government in the amount exceeding $500,000. And that statement is found exactly on SA 2630. To date, it states, completion of the project has been affected by the large amount of change orders which has been required to be completed in excess of $500,000 issued by the government that has been directed and performed, increasing the project scope.
So is there any prejudgment interest included in that $568,000 award?
In the award against Hirani, yes, there was, okay? There was prejudgment interest issued on both, I believe, by Judge Mehta in the amount of approximately 6%.
Right. So what I'm getting at is there overlap there? In other words, the 568 was just supposed to be as a result of the change orders. But it also included, did it not, some award of prejudgment interest?
Yes, it did.
And how did the
It did. But the award against Hirani was for only 85% of the base contract work. If one looks at the contract on Hirani, that Hirani signed with ACC, I call it ACC, American Construction. It just says in Article 4 on AA 279, Article 4, changes in the work, that you will proceed with the changes in the work. It doesn't say how you get paid. It doesn't say what normally every construction contract says how you get paid, whether you get paid a unit price, whether you get paid. It just says you have to proceed and you can't stop. And basically our client, ACC, never stopped until until the prime contract was terminated, and they were directed to stop after the September 1st date by Hirani.
Can I ask you the following question? So you don't take issue with the proposition that if the award against Colonial and the award against Hirani for the same work, that you can't recover against both of them for the same work, right? That would be a double recovery, and that's just not something that the district court presumably intended to do, and that's not something that you're claiming you're entitled to.
Yeah, it is certainly not the same work. One was 85% of the original scope of the work. The scope of the work was substantially expanded by the 27 modifications, suspensions, differing site conditions, and change directives, and the effective designs that took an 8-month agreed upon schedule. That's what Hirani and ACC agreed upon, an 8-month schedule. And it lasted for 25 months until it was terminated. And then, Judge Mehta wrote 3 marvelous, well-defined published opinions on this case. The only problem I had with Judge Mehta was on not covering the a reasonable value of the supervision of the 8 workmen by that had to be done. On-site supervision is covered by labor under the Miller Act.
So let me ask you, one of the key cases here is the 8th Circuit opinion, which the district court does cite. And the district court there, Judge 8th Circuit, Judge Kaufman, he argues that the standard is, he goes through Supreme Court cases, other circuit cases, even cites some cases from this court for the proposition that the Miller Act is to be liberally construed to be sure these workers get paid. Judge Kaufman writes for the 8th Circuit, quote, thus, the on-site supervisory work of a project manager falls within the purview of the Miller Act if such a superintendent did some physical labor at the job site or might have been called upon to do some on-site manual labor in the regular course of the job, close quote. And that's at his opinion, 972, Fed second at 991. So under that standard, what is it here that would bring Mr. Hollander under that test?
Basically, the physical work, the contract requires supervision. On-site supervision requires also traffic control. And Mr. Hollander did the traffic control, did the supervision. The other one specifically, Your Honor, let me just get the actual subcontract out. Supervision, traffic control, layout work. He basically was the engineer doing the layout work, and he also has to certify that the work was done according to the plans and specifications.
So you think that is consistent with?
Oh, it says supervision. The project on O2 on Schedule B in the subcontract says you must provide project supervision, a superintendent, safety officer, and traffic control officer. And that was, in fact, Ed Hollander's duties to do all three on site. But all the other cases, Buttonhead, and all the other cases, there are 5 other cases that were cited, is if in fact you are on site and supervise or inspect the work, you have to inspect the work in order to certify that the workmen are in compliance with the plans and specifications. And that has to be done.
All these cases were cited to the district court, and where do you think it made its error?
I believe, as I told him, he made the error saying he had to do physical labor. You're talking about, I grew up in the industry, all the agreements with the unions say if you have 9 or 10 men, you have to have a superintendent or a foreman who is non-working. Does that mean he doesn't get paid? This would cause tremendous havoc in the industry. If in fact,
I think what Judge Kaufman was getting at was, how do you distinguish? And maybe it's between the supervisory work that is not covered by the Miller Act, namely what you might do back in your office, any sort of expertise you might have in connection with, I don't know, architectural drafting or something like that. So I understood his test didn't require physical labor, but it had to be.
That's right. The distinction is on-site supervision and inspection versus off-site administrative work, reviewing shop drawings, doing takeoffs and stuff like that. That's not covered. That's professional, and that's not covered under labor. but under the Miller Act, on-site supervision of the workmen, on-site land surveying is covered, on-site safety and officer and traffic control. That is covered. That's labor that you have to have in order to advance the prime contract. And it's that simple, Your Honor. And that's always been the criteria.
I basically think that the district court here, Judge Zell, for instance, wrote an opinion that there's some common sense that has to be applied here. And I just wondered why the district court, who's certainly an able judge, as they all are, didn't appreciate this point.
Absolutely. Judge Gazelle, you know, I argued the Mariani case, and the young man that's sitting here right now, Larry Shura, was, you know, one of the counsels. That was 50 years ago when it was the Hirani Museum that was being built, that's now been torn down and now been rebuilt. So I'm 50 years older, but that was the criteria. Judge Gazelle said the same argument is being made today. He says, okay, you paid them what was in the original contract, but that's not the criteria. The criteria is the unpaid reasonable value of the labor and materials that you actually supplied. You know, it took 2 more years for Parachi to finish the construction.
So let me ask you one other question. I'm sorry, Chief Judge.
Oh, please go ahead, Judge Rogers. Please go ahead.
One other question. You argue, and I want to be sure you continue to argue, that this issue that is now being raised by Colonial was never raised in the district court. Namely that.
Correct.
Yeah.
And Judge Mehta never had a chance to distinguish what is being raised right now. We're off the line, by the way. Ed,
we can still hear you, so you can continue.
Judge Mehta never had a chance to answer what is being raised now on appeal for the first time. In fact, when they objected to the damages that Judge Mehta proposed, they proposed some $800,000 for Colonial and less than, I think, $300,000 for Hirani. That was the same thing. They never said, okay, $300,000 for Colonial and Hirani. It was almost 3 times more that they proposed for Colonial than Hirani.
Thank you.
Thank you, counsel. I think unless my colleagues have additional questions for you. Thank you, counsel. We appreciate your argument this morning. Mr. Delaney, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Just 3 quick points I'd like to address that were raised by Mr. Prouty. First and foremost, with regard to the waiver issue, might as well get that one out of the way front. The issue has to do with the divergent awards against surety on one theory of recovery and against the general contractor on a second theory of recovery. That issue did not arise until the judgment was issued. The first action Colonial took after that judgment was issued, timely filing a notice of appeal. There's no waiver
Now,
argument.
did it not have an opportunity to file a motion for reconsideration?
We certainly had the opportunity to, Your Honor, but not the obligation.
I understand that, but you know, the district court, as he begins his opinion, says almost, these are my words, not his word. I can't believe I'm being asked to examine this voluminous finding and ruling once again. And he said, I'm simply not going to examine the minutia of, you know, whether a bottle of Gatorade was properly in the award. And so that's why I'm getting to the point that the district court thought he had covered everything that was raised. And if it was never raised before the district court, then on what basis could we reverse at this stage?
Again, Your Honor, we timely appealed it for the first time after the issue arose. I'd like to briefly touch on the issue on whether or not the awards were for the same work. The complaint, the second amended complaint, which was Mr. Browdy's first entry into this litigation, there were attorneys who represented plaintiff prior, sought the same amount of damages, $2.074 million against both Hirani on a breach of contract basis and against Colonial on a Miller Act basis. It's always been the same stuff under different theories. It was never.
And the district court didn't award it.
And the district court didn't award it, just like the district court specifically rejected the same arguments that Mr. Browdy just made regarding the supervisory work allegedly performed by Mr. Holland.
You didn't raise that at all in your opening argument, so I think we have the argument.
Thank you very much, Your Honor. Judge, any more questions?
I don't think so. Thank you, counsel.
Thank you.
Thank you to both counsel. We'll take this case under submission.
Nice day.
Thank you, Your Honor.